Welcome back. Time for video 2 for adverse possession. It doesn't get more fun than this. In this video, we're going to go over the mechanics of adverse possession. So what we're going to do is we're going to talk about the various elements of adverse possession, how courts have interpreted them, and most importantly, we're going to work through some problems about how to use this body of law to interpret situations. Again, the cases I asked you to read are just examples. There's nothing special about them, and their only purpose is to help you understand how this body of law works. What really matters is, can you use it to answer the next question? So I will never ask you a question of what was the use of the property in the Brand case. Who cares? What I will ask you, though, is I'll give you a situation, and then I'll ask you, under the circumstances described, can somebody make an adverse possession claim or not? Okay, so think about it in those terms. Think about this in really practical terms about how to use this law to analyze situations. With that caveat, let's start with the adverse possession law in New York again. Right, these are the elements of an effective adverse possession claim. Again, I want to emphasize that courts frame this a little bit differently each time. So sometimes you'll see courts say there are 5 elements. Sometimes you'll see courts say there are 4 elements because they'll combine open and notorious and exclusive, or they'll combine exclusive and continuous for the statutory period. Don't worry about that. This isn't criminal law where the elements are so important. Right? What you want to do is you want to look at a set of facts and think functionally. Has the person who entered the land done the kinds of things that would trigger an ejectment action and would start the clock running for adverse possession? The things you're going to look at are, in particular, has possession been actual? Meaning, have they actually entered the land? If they haven't actually entered the land, then they're not adversely possessing, because until they've trespassed, there's no right of ejectment. Okay, so there has to be an actual entry in the land. Now, then that entry must lead to open and notorious use of the land. And that requirement serves a notice function. Whatever the adverse possessor does has to be a big screaming signal to the record owner, to the real owner of the property, hey, your rights are in jeopardy here, get busy with an ejectment. Okay, so they have to actually enter so that they're trespassing and triggering an action of ejectment, and they have to act in a fashion that lets the record owner know that they should be paying attention and starting an ejectment action. Has to be exclusive. Now, what that means is not that nobody else can go on the property, but that the adverse possessor is acting as the exclusive owner of the property. So much like the ordinary owner might invite people over, might even run a business where the public is welcomed into the property, but under the auspices of participating in that business, right? That's what exclusive means. It means that there can't be multiple people who are trying to exert ownership of the property at the same time. And then the possession must be continuous for the statutory period. We're going to bracket that because next class, when we talk about the doctrine of tacking, we're going to talk about what it means to say that possession is continuous, because that can be a little bit complicated. And now the one that I skipped as we were talking, possession must be adverse and under a claim of right. That's the one that seems like it should be the hardest, but actually isn't. In Hammond v. Baker, which I asked you to read, you see that the court says that they will assume that the use is hostile and under a claim of right if the other elements are satisfied. So if there was an entry that was a trespass and the land is being used in an open and notorious fashion as an owner would. If that happens, then courts typically presume that the use is hostile. Now, in 2008, the New York legislature amended the adverse possession law to make that claim of right have a little bit more teeth. After 2008, a claim of right means that there has to be a reasonable basis for believing that you are entitled to this property. Hasn't really been played out very much because the 10-year statutory period ended in 2018. It's only the beginning of 2021, and 2020 was a year of COVID when the courts were shut. So we haven't really seen cases interpreting what this means yet, but it's something to keep an eye on. And there is a CUNY alum who is involved in an adverse possession case, and I'm trying to get him to come and talk to us a little bit about how he sees this 2008 amendment playing out. No promises, but that is my hope. Claim of right is one of the easiest in general to establish. At least it was until the 2008 amendment. Hammond v. Baker tells us that the court will assume that if the other elements are satisfied. So what does it mean to say, right, let's go back and look for a second, when possession must be adverse and under a claim of right? What this means is that it must be inconsistent with ownership in somebody else. Okay, the adverse possessor must be asserting a claim to the property that is inconsistent with somebody else having title and owning it. And in that, courts do not look at what is subjectively in the mind of the adverse possessor. They look at what the actions are on the ground. So here's an example. Paying taxes on the land is an act that is adverse and under a claim of right. It is an assertion that I own this property because it is acting like an owner would and is inconsistent with somebody else having the title. So we've talked about adverse and under a claim of right. Let's talk next about open and notorious. What does it mean to say that possession is open and notorious? Open and notorious gets combined often with actual possession. Right? There has to be an entry, and it has to be the kind of entry that gives a big signal to the record owner that they need to do something. So under New York law, land is deemed to have been possessed and occupied, right, when there have been acts sufficiently open to put a reasonably diligent owner on notice. That's super helpful, right? It defines itself as itself, or where it has been protected by a substantial enclosure. Building a fence, right, that sort of keep out, no trespassing signal that you get from a fence is a definite way to demonstrate that the land has been possessed, and it's an open and notorious statement that should put any owner of land on notice. If they go by their property and they see that somebody else has built a fence, that's a big signal that there might be a problem. Now, what about the first part, where there have been acts sufficiently open to put a reasonably diligent owner on notice? Right? That's the open and notorious actions. The classic open and notorious action is building a house or building a building of some kind. Right? That is a claiming of the land. It's pouring resources into the land. Farming land also is open and notorious action. And this doctrine gets invoked much more often in the context of farmland than it does in the urban experience. But there are definitely cases here in New York City about adverse possession. But the key thing to know about this is that there have to be acts that signal to the owner, hey, your rights are in jeopardy here, you better do something. And that's going to be a case-by-case analysis. But a fence or a building will generally satisfy that requirement. And if you look at what the court said in Brand v. Price, the court said possession must be such that would give the owner a cause of action for ejectment against the occupier. This is what we've been talking about. The actions that the adverse possessor takes must trigger a cause of action for ejectment in order for the adverse possession clock to run. Burkholz v. Wells, a case I didn't ask you to read, but it's one that you'll see it referred to in the cases you did read, explains that the point is that the actions of the usurper, the adverse possessor, should give the real owner notice that somebody else is asserting a claim that is hostile to them retaining ownership and that they should do something. Just sort of to recap a little bit. You have to have actual, hostile, and use has to be open and notorious. So as we said, if the land is cultivated, if the land is improved, if the land is fenced, those are actions that are typically considered to be open and notorious. They're not the only ones, but those are the easy ones. If those things haven't happened, if the land hasn't been cultivated, if there hasn't been a building or it hasn't been fenced, it's going to be more difficult to establish open and notorious activity. Doesn't mean it can't happen. And I just want to highlight that the special case, this is actually in the statute, when entry is under color of title, which we'll talk about in a minute, then harvesting firewood or timber on the land will also qualify as a use that is open and notorious. Whereas, right, it might be an open question in the run-of-the-mill adverse possession case, when entry is under color of title, and again, we'll talk about what that means in a minute, the use of land for firewood or timber will also qualify as use. So here's an assignment for you for this video, and it should be fairly straightforward. In the cases I asked you to read, what uses amounted to open and notorious use? And do you think that those same uses would satisfy the 2008 amendment? Again, you do not need to write me a volume. You don't even have to use full sentences to answer question 1. You can just list the case and then have a bullet list if you want, however you want to do it, but answer these 2 questions. Going back to when is land actually possessed, right? We were talking about how you have to enter land, you have to trespass in order for adverse possession to begin, right? That's the actual possession part. And there are 2 different rules depending on the circumstances of that entry. There's entry without color of title and entry under color of title. So that should have you saying, what's color of title? Color of title, which is defined in the statute that I asked you to read, is entering with a document that seems to give the person who is entering title. So it is, if you have some kind of a deed that is invalid in some way, right? It's a deed that, or a will, or some kind of a written instrument that purports to transfer ownership of the property to the person who's entering, but there's something wrong with that document, so it doesn't actually have the legal effect it purports to. Okay, so classic example is somebody goes away on vacation. They go away for a long vacation, a couple of months. And while they are away, somebody else goes into their house, lists the property, and sells it and closes, right? And there's a closing. The person is a complete stranger to the property. They don't own it, but they're pretending that they do. They are a crook, and they sell the property to somebody who's now paid, $200,000, $1 million, whatever, thinks they own the property, goes in. They have entered under color of title. They have an invalid deed. They have a deed that's written and signed. The problem is that the person who purported to sell it to them was lying, was pretending that they owned the property. So it's not a valid deed because it's not a deed from the record owner. And this actually happens. We'll talk about what that means a bit more in a couple of minutes. But for now, you should understand there are 2 separate rules. What happens when an adverse possessor enters with some kind of a document that purports to give them ownership of the property versus what happens when they enter without that kind of a document. And we're going to take that second situation first. So here's a hypothetical. Okay, this is our lovely 100-acre square farm, and O owns and lives on this farm. Okay, O has owned this farm for a long time, since 1975, and in 1994, A enters the property adversely, enters the part of the property that O doesn't go to anymore. Maybe O is old and doesn't sort of do a circuit of the property every day or every month or even every year. A enters the back 40 acres and occupies and improves it in the usual manner. A built a house, A has a garden, maybe even A has a fence, right? All of the things that signal that A's use is open and notorious. And then in 2015, right, after A has been there for more than 10 years, which is the statutory period in New York, A sues to evict O from the farm, claiming title by adverse possession. So the question is, what happened? Think about the gall here, right? A has got a lot of gall to try to evict O, the owner. But put that aside for the moment. So the question is, what happens when A sues to evict O from the farm? There are three options. A wins entirely. A gets the entire property and evicts O. A loses entirely and gets nothing and O can evict. Or A obtains the part of the property that A has occupied and used through adverse possession. So what do you think the answer is? The answer is number 2. A gets the back 40 acres. An adverse possessor who enters without color of title can only get the land through adverse possession that they have actually used and occupied. Okay, so here's the statute. New York Real Property Statute 522. Essentials of adverse possession not under written instrument or judgment. The part that is key is land is deemed to have been possessed and occupied in either of the following cases and no others. Where there have been actions sufficiently open to put a reasonably diligent owner on notice, and where it has been protected by a substantial enclosure. Okay, so when entry in New York is without color of title, the adverse possessor gets the land only that they have used openly and notoriously, or have put a substantial enclosure around. And I apologize, there should be an or between 1 and 2 on this slide. Okay, so if we go back to our problem here, A entered the back 40 acres and used it, we said the problem tells you, used it in a manner that was open and notorious, which means in 2015, because A entered without color of title, what A can acquire is the part of the property that A used in a fashion that satisfies this. Reason, right, has been open and notorious and or protected by a substantial enclosure. Okay, I hope that's clear to you. If not, we can start next class with some questions about that. Okay, we're going to end this video here, and then we're going to pick up with entry with color of title in video 3.